Forensic Accountants. And in this webinar, which I'm hoping will be about 30 minutes, we are going to start to deal with the Law Commission consultation on confiscation. So let's have a look at the agenda. First of all, we'll talk about the consultation itself and the purpose of it. And then we'll talk about the purpose of confiscation. And then we'll have a session which I've called Before the Hearing. Before the Hearing covers a kind of a multitude of sins, but we'll get to that. And then early resolution, and that's a particular topic that is dealt with in the consultation. So let's have a go. The Law Commission, of course, is an independent body, independent of government, but it was requested by the Home Office as long ago as 2018 to have a look at confiscation legislation. They are looking at Part 2 of the Proceeds of Crime Act 2002, POCA, which we all know and love. Because they're looking at Part 2, of course, they are concerned with the law as it stands in England and Wales. As we know, Parts 3 and 4 deal with Scotland and Northern Ireland, and they are outside the Law Commission's remit. Having said that, one would think that if some very useful ideas come forward in relation to confiscation in England and Wales, that those would perhaps be copied across to Scotland and Northern Ireland where they're applicable. They're not addressing directly compensation. There is, of course, legislation about compensation of victims of crime. POCA is concerned with confiscation. And although there is a little bit of overlap, as we will mention, they are directing their minds towards confiscation rather than compensation. And they're not directing their minds towards civil recovery, which is under Part 5 of POCA. So what we're dealing with here is purely the situation in which a defendant has been convicted, or possibly has absconded without being convicted, and is subject to a confiscation order based on offences. The consultation, I'm sorry to tell you, runs to over 600 pages, the consultation document. And there are over 100 consultation questions which you are invited to answer. I should say that the Law Commission have made it clear that they don't expect everybody to answer all 100 questions. What they're looking for is feedback on relevant questions from you. You're not expected to be able to address all of the questions. Undoubtedly, there is a tremendous amount of valuable material in this consultation document. And whilst I do personally have one or two criticisms or one or two things that I think perhaps should have been covered and haven't been covered, that doesn't take away from the tremendous amount of valuable material there is in the document and the tremendous amount of work that has been done by a lot of people in putting that document together. There is much too much stuff to cover in 30 minutes. So what I'm going to do today is just to cover some of the stuff. And then in a fortnight's time, we will return to this consultation and talk a bit more about it. Even over a longer commentary, I am inevitably going to be selective. I'm not even going to attempt to cover all the points that are made in the consultation document. I'm not going to attempt to cover all 100 questions, all 600 pages by any means. I'm going to cherry pick the bits on which I've got something to say. You may feel that 600 pages is too much to ask you to read in full. And I would have a lot of sympathy with that. I have struggled to read a large part of it myself, and I'm used to spending quite a lot of time on confiscation. What I would suggest in that circumstance is that, if you like, try just reading chapter 1, because chapter 1 is, if you like, a summary and overview of the consultation document as a whole. Even chapter 1, I'm sorry to say, runs to nearly 40 pages. But if you read chapter 1, it will also give you a lead to where in the rest of the consultation document there might be bits that particularly interest you. One of the purposes of the consultation is given in the consultation document, and it says this: the review will aim to simplify, clarify, and modernize the law on confiscation by considering amendments to the current legislative regime and recommendations for the creation of a new confiscation regime through legislation. So what they're saying here is that they are considering some fairly significant amendments to Part 2 of POCA, some fairly significant changes in the way things are done, including right from the start, from initial restraint prior to charge to through to enforcement and default proceedings and so on. In practice, however, there are some useful ideas in there which could be implemented immediately that don't actually require any change to anything other than the way that we use the confiscation legislation. And there are other suggestions which could be implemented by amending the criminal procedure rules without primary legislation. So there are possibilities, to my mind at least, that we could use some of the output from this useful, valuable consultation document at an early stage. The first question they ask themselves is what is the purpose of confiscation? And you might say, well, why do we need to ask ourselves that? One of the reasons that we are addressing that, or that the consultation addresses that, is that there has been perhaps a little bit of confusion in case law as to the entire purpose of confiscation. And at the end of the day, of course, when we talk about issues like proportionality, one of the questions that the court is asking itself when it considers whether an order to pay X amount is proportionate is, what is the purpose of confiscation? What's the purpose of the legislation, as some of the case law refers to it? What's the grain of confiscation legislation? So, unsurprisingly, I would think, for any of us with experience of confiscation, they say that the principal objective of the confiscation regime should be depriving defendants of their benefit from criminal conduct within the limits of their means. Now, you might want to debate from that exactly what is involved in depriving, and how does that relate, for example, to tainted gifts and so on. You might want to debate what do we mean by benefit, and you might want to talk about the limits of their means and hidden assets and all that sort of thing. But the basic fundamental point they're saying of confiscation is depriving defendants of their benefit from criminal conduct within the limits of their means. And that sort of phraseology will be familiar to those of you who have dealt with confiscation case law. There are secondary objectives as well. And here they do mention compensation of victims where such compensation is to be met from confiscated funds. So they're not talking about the generality of compensation, they are talking about where it overlaps with confiscation, because confiscated property is going to be used to meet compensation claims. And they talk about deterrence, and they talk about disruption of crime as a secondary objective. I've seen a confiscation order being referred to as a deterrent penalty. And it seems to me that that is something which is accommodated in the Law Commission's suggestion of secondary objectives. But you will notice an objective which is not there, and it's deliberately not there. They're saying that confiscation is not about punishment. Punishment, they say, is dealt with by the sentence, the period of imprisonment, or whatever it may be. Confiscation is not topping up the punishment. Before the hearing, now I've used this heading, as I said, to cover a multitude of sins. One of the issues before the hearing, of course, is restraint, restraint of property, the risk of dissipation of assets if there's no restraint, balanced with the interference, if you like, with the owner's use of his own property, which arises from restraint. There are a whole load of issues connected to restraint, and they take you right through to enforcement after the confiscation order has been made, and how are assets realized if they're restrained, how are they managed, how are they kept from losing value during a period which might be years between the initial restraint order being made and the realization of the assets for to satisfy a confiscation order. All of that, having talked about it, I'm going to say I'm not going to talk about it. All of that I'm going to save for later when we talk about enforcement, because it involves also the issues of enforcement receivers and so on. Postponement. Now, this issue is a striking one because I have to confess I have never bothered much myself about postponement. I've always thought it was just something that happens and toddles along in its own sweet way, and I needn't worry about it. And it transpires that I, for one, and I suspect an awful lot of other people, according to the Law Commission, have misunderstood the legislation on postponement, have misapplied the legislation on postponement. So I do feel that quite often in confiscation proceedings, parts of the confiscation law might be misunderstood or misapplied. Clearly, I'm guilty of that as much as anybody else. The Law Commission refer particularly to a case from 2009, the Galini case. The reference is there, it's on Bailey. And the issue was the court proceeding or postponing under section 14, subsection 1? Now let's have a look at section 14, subsection 1. Subsection 1 says, the court may, A, proceed under section 6 before it sentences the defendant for the offence, or postpone proceedings under section 6 for a specified period. I thought I understood that, and I didn't. I didn't understand it correctly because as we know under section 14, if there's a postponement, we come along and to a 2-year time limit, which can be extended in exceptional circumstances and all that and all that. And I'm sure you're all familiar with all of that. I had always thought that that 2-year time limit applied to the making of the confiscation order. In other words, that if the judge didn't make a confiscation order when he dealt with the sentencing, then he had to make that confiscation order within 2 years of the date of the defendant's conviction. I now understand that that's not what section 14.1 means at all. What section 14.1 means is that if we are proceeding under section 6, proceeding under section 6 doesn't involve making an order, making a confiscation order today. What it involves to proceed under section 6 is the court deciding that there will be confiscation in this case, and the court setting a timetable for matters to be dealt with. So that if the judge prior to sentencing says, it's going to be confiscation, I want a section 18 order requiring the defendant to produce information by the 25th of February 2021, I want a section 16 statement by the 31st of March 2021. If he says that, then he has proceeded under section 6 just by doing that. And then he has brought himself, unless he says otherwise, he's brought himself within 14.1a. He has proceeded under section 6 before sentence. And if he's proceeded under section 6 before sentence, then all this stuff about the 2-year time limit doesn't apply. The only time limit he's then got is under the human rights legislation. He has to deal with it within a reasonable time. But the 2-year time limit does not apply if he set that timetable before sentencing, because he is proceeding under section 6. If, on the other hand, he sentences first, then he can postpone proceedings. And if he can set a timetable, and this is the problem, that what he does is very similar to what he would do under 14.1a. He can set a timetable then, post-sentencing, for the delivery of section 18 information and section 16 statement and so on. And if he does it that way, then he is postponing proceedings, and the 2-year time limit applies. And the 2-year time limit applies to fixing the timetable, not to making the order. So having postponed and then fixed the timetable, he's done enough to satisfy the 2-year time limit. So again, there's no statutory deadline on the date of the making of the order. That is what the Law Commission is saying section 14.1 means. So not perhaps what many of us understood it to mean at all. But the Law Commission is saying, well, there's all sorts of problems with the way confiscation is dealt with. Most worryingly, it tends to drift. Things don't get dealt with promptly. They don't get dealt with in a satisfactory way. They say that part of the problem is this postponement legislation, and they are proposing that we do something really rather different. First of all, they say, well, why not have sentencing precede confiscation? Why should the norm in the legislation be that the confiscation comes first, when the reality is, as we all know, it's usually not possible to deal with confiscation before sentencing. So let's recognize that. Let's say, right, the sentencing should precede the confiscation, not the other way around. And let's say that forfeiture and compensation orders are permitted at sentencing and before confiscation. Now that turns on its head the approach that we have at the moment under the legislation, where expressly forfeiture and compensation orders cannot be made before the confiscation order. And let's set an extendable 6-month time limit, not a 2-year time limit, a 6-month time limit after sentencing, not after conviction, after sentencing, for a decision to be made to proceed with confiscation and the setting of a timetable. So we're not talking here of a 6-month deadline for making a confiscation order. We're talking of a 6-month deadline after sentencing for a decision to be made to proceed with confiscation and the setting of a timetable for section 18 order, for section 16 order, for section 17 response, and all that sort of stuff. And the 2-year time limit being done away with, and there being no express statutory time limit on the making of a confiscation order. That is what the Law Commission is suggesting here. And they're saying, let's have standard directions. Why shouldn't we have standard directions? We have standard directions in criminal cases. Why shouldn't we have standard directions in confiscation with normally a 28-day period for each stage? So if you like, the Section 18 statement to be prepared within 28 days, the Section 16 response to be within 28 days after that, the Section 17 response to be within 28 days after that, and so on. Why not do that? Or if the case is a bit more complex, 56 days for each of those stages rather than 28. So that it would be a matter of routine to put forward these directions for confiscation hearings so that things are then moving along. And then they say the judge should be involved in active case management based around that timetable that he will then have set. They also say, and I've heard this from other people as well, that the confiscation papers should be on the Crown Court DCS. At present, they're not. Why not? The court trial papers are on the DCS. Why aren't the confiscation papers on the DCS? And they also suggest that the judge should formally speak to the defendant in open court at the beginning of this process, spelling out the disadvantages of a failure on the defendant's part to respond to a Section 18 order or a Section 17 order. Using a standard set of words that could be drawn up for judges to use in this circumstance, so that the defendant in the court is told this at the start of the process. They're suggesting as well more detailed, and I would say actually much more detailed requirements in the criminal procedure rules and in a practice direction attached to the criminal procedure rules as to how confiscation should be dealt with and progressed through the court. Now, of course, the criminal procedure rules can be amended without primary legislation going through Parliament. And then they make an interesting suggestion, and I think it's a good one, that the Section 16 statement be reframed. At the moment, they suggest it's perhaps a bit of a muddle of facts and inferences and law and all chucked into the mix, so that it's not always easy to distinguish what is accepted fact, what is inference, what is a submission of law, and so on from the Section 16 statement. Also, they're saying some Section 16 statements have got very long. So what they ask for is concise pleadings, similar to the sort of pleadings you might see in a civil case statement of claim, and then supporting statements and exhibits annexed to those pleadings, and if it's appropriate, a skeleton argument also annexed to those pleadings. So you've actually got three documents together here. The pleadings, concise pleadings, supporting statements and exhibits, and if appropriate, a skeleton argument. And one of the consultation questions concerns, should a lawyer be involved in drafting the Section 16 statement? Now, I have to say, my own answer to that would be yes, because I think there very often are issues of law which are dealt with in the Section 16 statement, which are arguably not fully understood by the author of the Section 16 statement, who, let's face it, is not a lawyer, is not an accountant either, is a accredited financial investigator. But to take one example, how many times have I seen in a Section 16 statement a paragraph towards the end that says there are no issues of proportionality arising? And yet in the body of the Section 16 statement, there are issues of proportionality arising. The Section 16 author has perhaps reduced his benefit figure because some stolen money has been repaid to the victim or something like that. These are issues of proportionality. And to say then at the end, there are no issues of proportionality, it's just plain wrong. So as I say, my answer to that question, should a lawyer be involved in drafting a Section 16 statement, would be yes. Even if that's only from the point of view of reading it before it goes out, just to check that any legal points have been properly addressed and picked up. The Commission proposed that the Section 17 response should be similarly laid out. Now, one of the issues that they don't address here is, what about if you've got a forensic accountant? What about if you've got an expert witness in there? What is their input? Does it go in the Section 17? Does it go in a separate document? How should that be dealt with? They haven't actually addressed that. They also say, and this is somewhat incidental, but very useful, I think, that there should be a single database for confiscation information, which is currently found in the JARD, in the asset database, and in confiscation papers. And they suggest that this should all be merged together in one place. And again, a sensible idea, I would have thought. Moving on, because I'm going to overrun my time, I can see here. They also talk, and this is again a very revolutionary suggestion, perhaps, about early resolution. So what happens currently is that issues might be identified only on the day of the hearing. Important issues might only come to light when everybody lands in court for the confiscation hearing. That very often, as we know, the reality is that matters are resolved by agreement, but sometimes the records of those agreements are scant or even non-existent, and there may be no record of the reasoning behind agreed figures. Now, admittedly, sometimes there might be no reasoning behind agreed figures, but nevertheless, if the matter comes to appeal, or if the matter comes to a Section 22 re-examination or a Section 23 re-examination, then you really need to know, why was that done on the day the confiscation order was made? And there may be no record of that. And of course, under Section 22, you might be looking at something that happened 10 years ago. So what they propose is what they call early resolution of confiscation, EROC. It sounds a bit of an unpleasant term, EROC, but there we are. They're suggesting an EROC meeting should be held. Now, an EROC meeting that they're talking about here does not involve the judge, is not necessarily at court. It involves both sides. It involves the defendant, but it doesn't involve the judge. The judge isn't privy to what goes on at an EROC meeting, except insofar as he's informed afterwards. Now, I have experience in confiscation cases of sometimes a judge saying, let's have a meeting of experts. Let's get Mr. Winch, the forensic accountant instructed by the defendant, to sit down with the author of the Section 16 statement and see what they can thrash out. Now, of course, that's a little bit of a misnomer, because the author of the Section 16 statement is not an expert in the sense that expert witness is used in legislation. He is certainly a skilled person, he or she, a skilled person, a competent person by all means, but not an independent person. He's a person who's working hand in glove with the prosecution to put the prosecution's case in the confiscation. So strictly speaking, it's not an experts meeting. And also, of course, if I'm meeting with the author of the Section 16 statement, I'm not acting on behalf of the defendant. I am an independent expert instructed by the defendant through his solicitor. I'm not there to negotiate on behalf of the defendant. I don't represent the defendant. So what's being talked about here as an EROC meeting is something very different. An EROC meeting is where the defendant is present, his representatives are present, the prosecution are present, and they can thrash things out not in court, not in front of the judge. And then following the EROC meeting, there might be a settlement that comes out. Figures might all be agreed. Or there might be a situation where some things are agreed and other things are not agreed. But it should be clear at the end of that meeting where everybody stands, what is agreed, what is not agreed. And then the proposal is that after the EROC meeting, there should be an EROC hearing at court in front of the judge. And what the judge is going to do there is to either consider and hopefully approve the agreement that has been reached by the parties at the EROC meeting, or if there's no agreement or incomplete agreement, deal with case management issues leading to a contested hearing on the matters which are not agreed. So that's the proposal, if you like, that there should be a get-together, not in court, not in front of the judge. It is, in some senses, the same sort of thing that happens very often at 10 o'clock in the morning, doesn't it? On the day of the confiscation hearing, everybody gets in little sweaty rooms at the Crown Court and starts having earnest discussions, and then counsel bob from one side to the other, trying to sort something out, and bob into court and say to the judge, can we have some time, please, Your Honour? And he'll say, yes, come back at 2 o'clock. You know, we're very familiar with that sort of thing happening, but the proposal is that instead of doing this at the day of the hearing, having the court tied up there, having the court having planned for, let's say, a 3-day confiscation hearing, which then may not happen, and all sorts of upset to timetables and so on. Instead of doing it that way, why not have a meeting not at court, not involving the judge, where a lot of these things can be thrashed out? And that, it seems to me, is a sensible idea. I'm asked, who's going to pay? Who's going to pay for that work? Yeah, a very good question. Legal aid doesn't do a great many favours to any of us in terms of confiscation. And certainly, I wouldn't be keen on barristers being asked to do yet more work for which they get zero pay. It's got to be paid for somehow, hasn't it? If it's saving court time, if it's improving the administration of justice, then it's got to be paid for. Somebody's going to have to pay. Okay, so just rounding up, just to remind you, Bartfields Forensic Accountants remains fully staffed. We're undertaking legal aid and privately funded criminal and civil forensic accountancy work. We're very fortunate in that it's easy for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities. And we are readily contactable by phone, by email, and online. And I'll be giving you the email address at the end as well. Our recently updated website is full of useful information. There's something like over 100 blog articles dealing with technical issues, as well as some less technical ones. And of course, that's accessible 24/7. You can find more on this and other topics on our website. This and previous webinars can be found again on the website. The link is there. This webinar has been recorded and will be available in a few days on the website, and I believe you'll get an email giving you the link. In terms of questions, if you've other questions, by all means email me those. I will answer them, and we will come back to this topic of the Law Commission consultation in a fortnight's time and talk about some of the other issues to do with moving onwards towards what is benefit, what is available amount, what do we do about enforcement. Website address and the phone number and my email address are on the screen there for you. I have overrun by 5 minutes. Apologies for that. And I shall look forward to seeing you again in a fortnight. Thank you very much and goodbye.